ahead and get started. Thank you so much for joining us this morning for the third in our series of webinars. That's a joint venture between the North Carolina Association of Long-Term Care Ombudsmen and North Carolina Association of Elder Law Attorneys. This webinar is going to focus on avoiding pitfalls in admission agreements in long-term care facilities. A couple of housekeeping. This is set up in webinar mode, so everybody's mics should already be muted. If you do have a question, we invite you to put that in the chat. If you need CEUs for this webinar, we invite you to please add your name and your email address into the chat. That will be how we are able to issue those CEUs after the fact. Throughout the webinar, we will be stopping after each presentation to offer an opportunity for folks to have questions addressed. So as I said, as we go along, please put those questions in the chat and we will make sure that they are addressed. I want to thank Jennifer Roden and Hannah Vaughn for being with us this morning. They are both attorneys and they'll be sharing with us the information about admission agreements. So I will turn it over to y'all.
All right, well, good morning, everyone. Thank you for joining us today. Today's topic is a pretty heavy one. It's one that often people have to face when it's an emotional time. We have put together a PowerPoint for you that has some basic information in there, but I will just go ahead and preface the whole presentation by saying that this type of topic can get very technical. And as lawyers, sometimes we tend to talk in regulations and codes, and we're going to try our best not to do that today. But there will probably be sections of the presentation that are a little more advanced, and there may be some that some of you are bored out of your mind because you already know about it. But we're going to do our best to keep things moving and share with you the pitfalls in admissions agreements, and at the end of the presentation provide you with some solutions and some things you can do. So we'll start out. I want to just introduce ourselves, let you know who we are. So my name is Jennifer Roden. I'm a partner with the law firm Craig & Fox in Wilmington. I have been practicing for about 10 years now. My only area of practice has ever been elder law. And so I am very, very familiar with admissions agreements with nursing facilities. I am a board certified specialist in elder law from the state of North Carolina, and I'm a certified elder law attorney through the National Elder Law Foundation. And today presenting with me is my wonderful colleague, Hannah, and I'm going to let her talk about herself for just a moment before we get started.
Hey, good morning, everybody. My name is Hannah Vaughn. I'm happy to be here today presenting with NALA and the Long-Term Care Ombudsman Association. Jennifer and I are both attorneys, and thank you for the preface on, we're going to try not to be too technical, but and if you have questions, put them in the chat. If we're speaking a language, you're like, what was that abbreviation? Feel free to, throw that in. We are going to take some time to answer questions throughout. They'll be we're going to do sections of the presentation and then open it for questions. And then there'll also be questions at the end. So putting it in the chat's the best way to let us know that when we get to a point where we're going to take questions, we'll address any questions then. So I am an attorney for the Corporation of Guardianship, and we are a provider of fiduciary and care management services for vulnerable adults in North Carolina. So as an elder law attorney, that's how I also identify, and the only practice area I've ever been in. But I now work for a nonprofit that provides services to older adults and disabled adults. Previously, I have taught. I've spent a lot of time teaching in law schools and paralegal programs, teaching elder law, and I've had almost 20 years of experience. And that makes me sound very old. When I saw that in my bio, I'm like, oh my gosh, 20 years. Where's the time gone? But I started my practice in North Carolina working with Frank Johns and private practice, and then moved on to teaching and some other wonderful things. And happy to be where I am now, and happy to be sharing with you some of our knowledge and insight we've gained along the way in working with long-term care facilities and various issues that we see in those admissions contracts.
So we'll start here. What's the likelihood of facility care for our seniors? And so, just some statistics out there for everyone. Our aging population is growing at a faster rate than ever before. Every day until 2030, about 10,000 baby boomers are going to turn 65. And, studies show that 7 out of 10 individuals, they're going to require some sort of long-term care in their lifetime. Doesn't necessarily mean in a facility, then maybe they can afford the care in their home, but they're going to need care as they age. What's really important to know in North Carolina specifically is that the 65 plus population grew by 500,000 people just between 2011 and 2021. And that 85 plus population grew by almost 30,000. All 100 counties in North Carolina have experienced growth in those populations, with the largest growth being in Brunswick County, Dare, and Orange County. I practice a lot in Brunswick County, so I can tell you that is absolutely true. People are moving here, and people are aging here. And so it's a great place to live, but it is a population that's growing, and they're going to need services. And so why placement in a facility to begin with? I think we all know that people want to age at home. I think that's a phrase that we use a lot, aging in place or aging at home. But obviously facilities provide a service that people need, but why are people ending up in the facilities to begin with? And so, there are really 5 main or top reasons. One, caregivers just can't provide the care that's needed in the home. Maybe the caregiver themselves is not in good health. We have seniors that have difficult behavior issues, and it may not necessarily be because of a dementia diagnosis. But often, I deal with folks that just the loss of some autonomy and independence really does change their personality, and they're difficult to deal with at home. There's a lot of pressure these days to place people in facilities. That pressure may come from family or friends. It may come from social workers. I've seen a lot of social workers in hospitals be put in a position of they've got to find a safe discharge plan for someone, and pressure or encouragement happens to place that individual in a facility. Medical professionals, right? They do have a duty to their patients to make sure that they're safe and getting the care that they need. And then sometimes it's just that the caregiver can't get the help they need in the home, right? Maybe the caregiver can provide great care, but they have to work. There are a lot of people who are in what we call the sandwich generation. They're trying to raise their children, and they're trying to take care of their parents. And so they can't retire. They can't be a full-time caregiver. They have to work, and they just can't get the people in the home to help them.
And I'm
Yeah.
sorry, I just want to interject one other thing. One other reason is sometimes related to funding.
Yeah.
We have good funding for facility care in North Carolina, or we do have funding for facility care in North Carolina, and not as much for at-home care. And so sometimes it may just be a cost consideration, which brings us to our next slide.
Yes, so cost of care in North Carolina. So these numbers came from Genworth. If you're not familiar with Genworth, every single year they do a cost of care survey nationally and then per state. I use this a lot when I'm trying to figure out what is a reasonable cost to pay a family caregiver when we're dealing with caregiver contracts and things like that. So what Genworth has shared for 2023 in North Carolina is that in-home care will run you anywhere from $5,200 to $5,400 a month. But I think it's important to note those numbers from Genworth are not for 24-hour in-home care. I think we all know that if you're talking 24-hour care in a home, you're looking at $21,000 or more a month to keep someone home. The assisted living facility care is around $4,700. Now that's an average. I'll tell you, in New Hanover County, that's super low, not even close to what it would really cost. And skilled nursing, they had it about $9,500 a month. And I would say and at least in my area, our facilities are charging somewhere between 11 and 12 in private pay per month. So the cost of care to keep someone at home, again, is a big deterrent. They can't keep people at home. And then when they do go to a facility, the cost of care in that facility is just unaffordable for folks. And there are very few folks who can afford to pay that private pay rate to live in a facility. So if you have participated in the other webinars, our very first one, our ombudsman did a wonderful job at talking about, the different levels of care at the different facilities that we have. I just want to remind everyone that today's presentation is focusing on 2 types of facilities. We have assisted living facilities and the skilled nursing facilities. And you're going to see on every slide that we tried to break it out in a column for each. because each is regulated very differently. Each has its own rules. But it's important to remember that depending on the level of care a person needs and where they live, that tells us what laws actually control an admissions agreement. So for folks in an assisted living facility, they need assistance with some ADLs, activities of daily living, maybe some Medicaid management, assistance with bathroom or dressing or grooming. But typically, these are going to be folks that, when prompted or helped, they can do things for themselves. They don't need 24-hour care, someone supervising them all the time, unless maybe they're in that memory care unit at the assisted living facility. And then a skilled nursing facility, really just as simple as it can be, that's for someone who needs full-time care by specially trained staff, right? They need medical staff there to help them do everything and make sure that they're cared for. And so how do you pay for all of this? So I'm in private practice, and every single consultation I have about long-term care planning, this is where we get stuck, right? How do you actually pay for it? And as elder law attorneys, we're always walking this fine line of not being a financial advisor, because we cannot advise people on the right way to invest their funds and pay for things. But it's important that they know that each facility or level of care, there are different ways to pay for it. So for an assisted living facility, you have private pay, of course. Some long-term care insurance policies will cover it. If you don't have a long-term care insurance policy, there are different types out there than the traditional policies that people are used to. Traditional policies where you paid an annual premium, and that premium went up every single year. And sometimes you had an inflation rider, sometimes you did not. And if you didn't use it, you lose it. So it's like any other insurance policy you have for your house or your car, right? If you don't need it, that's great. But if you need it, you've got it. The problem with the traditional policies, and this is where I'm getting a little technical, sorry. The problem with the traditional policies is that the insurance companies did not really plan well. So they were providing these traditional policies to folks were paying their premiums, and they were living too long. And so insurance companies were losing money. So we have fewer companies that will actually sell the policies. And now the new thing that they're offering for folks they're more like annuities or long-term care insurance policies, or life insurance policies with a long-term care rider. Those are more expensive on the front end because you pay a pretty large premium. And so I would just say that, at least in my practice, I don't see a lot of folks who have long-term care insurance. And if they do, it's capped at a pretty low number. And so if they need assisted living facility, the most the policy will pay might be $150 a day. And so that's not really a whole lot of money if you're looking at a facility that charges $250 to $350 a day. So again, special assistance can help for some folks with an assisted living facility. If you've participated in the past webinars, you know that is just a pitiful program right now. It doesn't really cover many people. Most people can't qualify if they even worked and put into the Social Security system. And the other issue is most facilities don't want to take it anymore. It's not enough money. Getting paid $1,500 a month to care for someone is not a good business decision anymore. So we do have some facilities that take it. Again, not a very popular program. And then there's VA aid and attendance. And so if you have an individual who's qualified for VA benefits and they need assisted living care, they may be able to qualify for aid and attendance to help pay for that. And you get on the skilled nursing side, you got private pay, you have long-term care insurance, you have Medicaid. And Medicaid, again, has very strict rules to get into that program. And then Medicare will cover rehab days, but it's not going to cover the actual long-term care stay. We're getting there, I promise.
Long intro, but it's
yeah,
important.
It is a long intro. We have to figure out how in the world did we get here, right?
Yeah.
So admissions agreements, wait, don't sign it yet, right? I think that admissions agreements themselves are only getting longer. The average length of an admissions agreement that I review in my office is at least 60 pages. And it's a lot. They're very lengthy, they're complex, they're often deceptive because they have contradictory terms. I think every lawyer thinks they do it better than everybody else. Every time I review a contract, I find so many errors. And these are the typical contracts they use with all of their facilities across the country. And I will find where they've defined a term on one page and then they define it differently on another page. And so they're contradictory. So as an attorney, it's hard for me to even interpret them. I think common sense, we all know you should not sign a contract without reading it, right? Although I'm sure some of you have signed your cable contract without reading it, or your cell phone contract, right? But why would anybody sign an admissions agreement contract for their loved one to go in a facility for strangers to care for them, knowing that it's going to cost $9,700 a month? And, what is it about that situation? And I think that, it's all about the psychology of it, right? Placement in a facility often comes in the middle of an emergency or right after an emergency. People are put in a position that it's confusing, they're rushed, they're physically and emotionally drained. They have a loved one that they're just trying to get out of the hospital because the hospital needs their bed and they're pushing them out, or they're keeping them at home, but now they've used up all of their medical leave to take care of them and they've got to go back to work, and then they're losing money. And so I think what happens is folks get in a position that they meet with the admission staff at a facility who are usually very friendly. And those staff give them this 70-page document where they've marked up where they need to sign. And the family, friends, or the resident, they just expect everyone to be truthful and to be helpful, right? That their job is to provide a service. And what I have to remind folks of is it's also a business. And I'll take a step back just to say that in our area, the folks who run our nursing facilities, our administrative staff, are wonderful people. I've enjoyed working with them. But I think that their training on their admissions agreements is have the person sign here. They don't know the nitty gritty details either. They're not attorneys. They're not reading contracts for what they are. They're doing their admissions process. And so I think when the family's working with that administrator and getting all the paperwork done, and they're getting this vibe of they're being honest with me and they're just trying to help me, I don't think that that's wrong. I think that that's really what's happening, but it's on the back end when you realize what you signed that's the problem.
And Jennifer,
yeah.
I'll add a little bit to that. Just thinking about like when you enter into a really big transaction, like you buy a house, there's an attorney representing you in that process as the buyer of that house to review all the paperwork with you and make sure you're not, getting swindled in some way, and looking out for your rights. When you buy a car, it's another big purchase a lot of people make. There's no attorney holding your hand and walking you through that process. There's also some consumer protection things built into the law about car sales. So if you end up getting like a used car that's a lemon, there's protections in the law. There's been thought put into these big transactions that people enter into, consumer transactions that could potentially harm you, and there's protections built in place. And I don't think we've done that with nursing home agreements and talking to or any long-term care agreements. So I think that's where we're telling you, like, to advocate for yourself. This is a lot of money. Like Jennifer said, it's a lot of money. I mean, it might cost you more than a house, or definitely more than a car in some cases, to be paying this much money to the facility. So what we're encouraging is people to go out and get good information, get an attorney, get some advice, get somebody to hold your hand through this, because there isn't that natural kind of safety net of safeguards in place for consumers that I think are inherent in some other transactions.
Yeah, I think in the past, Hannah and I have even joked that we should just get billboards put up in different cities that say, wait, don't sign that admissions agreement, because I think it all comes down to folks feel rushed, pushed. It's an emergency. They need to get it resolved. They have other things they need to focus on, and the health care of their loved one is paramount, and they're not thinking about the financial impact on the back end. So it's important to read. It's important to negotiate and understand what you're signing. But sometimes it just means you have to just stop, right? And take a minute. So the technical side, there are different regulations depending on the type of facility. And so just to make it really simple, when it comes to an assisted living facility, there is no federal regulation that tells an assisted living facility what they can or cannot do when it comes to their admissions agreement. And in fact, the only law we have in North Carolina to deal with assisted living facilities is our statute 131D. But there's not a lot in there protecting the patient or the resident. Those regulations, those statutes have more to do with, the facility and how they get their license and how they run. And so I think you're going to see a theme pretty quickly through this presentation where the assisted living column doesn't have much because there's just not much there. Now,
it's the Wild West out there, guys. It's the Wild West.
Yes. Now, the skilled nursing side, right? We do have statutes in North Carolina, but the part about skilled nursing that's so important is we have the Nursing Home Reform Act, which is a federal law. And so that's going to trump, right? That's what controls. And so through the presentation, when we're referring to whatever the rules are, this is what we're referring to, right? Assisted living, it's 131D of the North Carolina statutes. And for skilled nursing, we're really going to be looking at that Nursing Home Reform Act. And now we're here. So pitfalls. There are many pitfalls in an admissions agreement. Today's presentation, we're going to focus on 3. These are the 3 biggies, as I say, okay? So we got our third-party guarantees, arbitration agreements, and reasons for discharge. And what we're going to do in the presentation, because again, this is very complex and we don't want anyone to feel like they're holding on to a question till the very end, is once we finish our presentation on a certain pitfall, we're going to take a step back and answer any questions you have to that point. And our hope is that that'll help you retain more and also help you remember the questions you want to ask. So, third-party guarantees. Hannah, is there anything about third-party guarantees for an assisted living facility?
There are no regulations about this, surprisingly. I think we should start with skilled nursing, Jennifer, and then say none of that applies.
None of that applies.
There really isn't any kind of prohibition on assisted livings asking for somebody who shows up with the loved one who needs care from signing the agreement and making themselves personally liable. So talking about what a third-party guarantor is, that's somebody who is agreeing to be liable for the financial cost of care for the person who's entering the facility. And, you would think, oh, well, the resident, it's their care. They should be responsible for it. If they've got insurance, it should go through their insurance, blah, blah, blah. Yes, I think they start there looking at the resident. But if somebody else has signed as a guarantor, whether that's a spouse or another family member, a friend, anybody who is facilitating the process of getting them admitted to the facility might be asked to sign as a guarantor and might not realize they've signed in that capacity. They might not know that that's what they've signed up for. They may think they're just, signing them in for a spot. And when really this is putting them on the hook for the entire financial bill that is incurred while the resident lives there. So there's not any real protection against that. I don't even think there's disclosure required, Jennifer. I mean, do you?
I have found nothing, and I research it often. I found nothing for an assisted living facility where they have to disclose anything. I would say that I look at a lot of assisted living contracts, and not as many of them have the guarantee in there that I would expect. But they're there and they're pretty bold about them, and they have the right to be, right? So when folks come and say, I want my loved one to go to this assisted living facility, but they're demanding that I guarantee the bill, and I tell them, well, you shouldn't do that. That's a bad idea for you. The question is, what does the facility do? Well, they're just going to say, well, we're not going to accept you as a resident. And that's easy for them, right? And they'll just move on to the next person who needs placement.
Clarification though, some people, they'll ask, well, do you have a power of attorney? Do you have an agent under power of attorney or a guardian who can sign for you? Yeah. And those people can sign and often do, but what you want to make sure when you're signing is that if you are the agent or if you are the guardian, you don't want to be signing your name without also indicating the legal capacity in which you're signing, because just signing your name puts you on the hook. Signing your name as POA for Joe Smith keeps the ball in Joe Smith's court, and you will use Joe Smith's resources to pay for Joe Smith's care. So there's part of it is attention and how you sign it. And I've seen people thinking they're signing as the agent because they are the agent, but they're just signing their name.
Yeah.
And that we would not recommend that. That's another reason, like if you came to one of us to ask how to sign this, we would tell you specifically how to sign in that legal capacity to make sure that it's clear that you're not personally putting yourself on the hook. Because it may not be a problem now, but if that bill doesn't get paid at some point, they're going to be coming to you.
And I will tell you from experience, so I had a case that was exactly that. A daughter she signed it the way I advised her. As a power of attorney, she signed her mom's name first, by her, POA, literally everywhere. She did not realize that she had signed a personal guarantee section, but she signed it as agent. And that my case actually ended up with the North Carolina Court of Appeals, and we won. And they said she signed in a fiduciary capacity. She did not sign as an individual. And so the facility had to eat that cost, right? What was tough is she had to pay attorney's fees to get there. And that's heartbreaking in itself, right? How much did she have to spend to protect money? But the way you sign it, no matter what contract you're signing, right? Even if it's buying a car or something like that, you need to sign in that fiduciary capacity. So for skilled nursing facilities, the Nursing Home Reform Act has made it very clear that federal law prohibits a skilled nursing facility from requiring or even requesting that a third party volunteer to guarantee the bill. In the past, it was just the word requiring, right? And so what facilities would do at that time is they had within their contracts a section that would say, do you want to join others in making sure that your loved one is not discharged from this facility when they run out of money? And then they'd have a check here or here, yes or no. And that was someone volunteering to pay the bill, because there's actually nothing in the federal law that said you can't request a volunteer to be a guarantor. But now the law's actually changed. And so they cannot require and they cannot request it. So if there is a contract that has anything in there that says you're volunteering to be liable for the debt, you can cross it out or ignore it. They shouldn't have it in there to begin with. That is a violation of federal law. So, facilities have had quite a history of trying to figure out a way to guarantee they're going to get paid. And so, that's what they would do at first, was the volunteering. And then they kind of moved on and said, well, if we can't request a volunteer, what can we do with the language within our document to bind someone? So then they started with this responsible party language within their documents. And this is where a lot of folks get tied up, because it will define responsible party in one section one way, and then it'll define it somewhere else another way. And if you don't look at the whole contract together, you won't realize that. And so when you're looking at an admissions agreement, we have the main agreement that might say responsible party is just the person who we notify when there's an issue. And then when you look at addendum A, it says responsible party is the person who is guaranteeing this bill if you can't pay it, right? And then responsible party in addendum C is something else. And if you don't look at all of it, it can get really confusing. If you're only looking at page one and you're just signing everywhere they tell you to sign, you're not going to realize that you're signing as a different fiduciary, right? You're not signing as the individual anymore. So nursing facilities have caught on that that's another issue, right? That their contracts are not written well. I'm not sure who's writing them, but they're not putting them together. They're not working well. And so now what they're really focusing on is the definition of a responsible party, or the person signing the contract. In the contracts, you are you're telling them certain things. Number one, you're telling them that you have the legal right to access the money of the individual who is going to live in the facility. And then you're telling them that you will absolutely use their money first and foremost to pay their bill. And then they also want you to guarantee that, when the money's running out at a certain point, that you're going to do a Medicaid application. That person's going to get on Medicaid. Absolutely. That you're not going to do anything there. And so what they're trying to set you up for is a contract claim, a breach of contract claim. They're trying to say that in our contract, you said you were the durable power of attorney agent. And now we find out after the fact that you are only healthcare agent, and that's a breach of contract. So now we're going to sue you. And they have been pretty successful with these cases. And I don't know, Hannah, how you felt in law school. I absolutely hated contracts. I just really struggled with the whole point. Contracts, there has to be an offer, an acceptance, and consideration. And the big argument for elder law attorneys dealing with a breach of contract claim is, what in the world is the consideration for the third party who signed the contract, right? If I sign a contract to put my mom in the facility, what service am I actually getting? I'm not getting anything. Every service that's being provided is to my mother, but some judges aren't getting that, right? Some juries aren't getting that. And so these facilities, their attorneys are going after the individual strictly on breach of contract claims. And so, I think that we're going to see less and less of the volunteering language and less of the confusing responsible party language. But you're really going to start seeing in these admissions agreements that have now gone from 60 pages. I think they'll end up being like 100+ pages. And they're going to put in a whole bunch of stuff where this person signing the document, that they can go after them later and say they breached their contract. I think the other thing to keep in mind with this contract, where they say that the individual is going to use the resident's money first and foremost for their care, is how much can they really dive into that? Right. So they're seeing a lot more cases like this in New York, where the facility comes forward and they say the durable power of attorney agent used the money inappropriately, and they want an accounting of how the money was used. Now they have no idea, right? They just filed I call it a frivolous lawsuit to try and get an accounting from the durable power of attorney agent. And then they go through and they nitpick everything. And they say, well, why did you, buy these supplements from Walgreens? They didn't really need that. You could have used that $100 to pay the facility, right? So it's putting that agent in a position where, is it a breach of their fiduciary duty, right, to follow the terms of the contract and pay room and board first? Or should they be using that money to buy a pre-needs burial plan, right? What is their duty? Who's their duty to? Is it to the resident or to the facility now? So you can see it can get really complicated. Because
and a lot of them ask for like a financial disclosure, right? When you're going into the facility, they want to know how much assets you had. And in their mind, they're calculating like, okay, how long are you going to be a private pay resident before we're going to have to accept the Medicaid rate for your care, which is lower. So they're kind of doing some math in their head on, is this a good business decision for us? And if you come in with $300,000, but you spend the agent, spends money repairing a home, or, I can't think of exactly what the big purchases would be, but spends the money on things other than care, red flags go up at the facility. Like, even if it's completely legitimate spending for the person's needs, it's a pre-need funeral policy. It's a long-term care insurance policy, which you wouldn't qualify for at that point. But it's something that's legitimately for the needs of the resident, but it wasn't within the contemplation of the facility that they would not get that money, and that they're going to get a Medicaid resident sooner than they planned for.
Yeah, absolutely. So at this point, I think Ashley and Christina, probably a good idea, if there are any questions on the third-party guarantees, that we cover those before we move into the next pitfall.
Yes, thank you. There are 2 questions. The first one, is there a pre-screening application that can be done ahead of time? So admissions aren't done only during a crisis. It's kind of a 2-part. And is there a government agency or nonprofit that will actually walk you through the entire process, complete with legal advice?
I
wish. Great question.
I'll cover the pre-screening for a second. I think the thing that a lot of my clients do to be proactive is they meet with me before it's a crisis, right? I do a lot of estate planning. And when clients come in and they're in their 70s and we're doing estate planning, I'm already talking about long-term care planning, right? I push that into the discussion, and I already talked to them about, what's your financial situation look like? What's your family situation look like? Do you have caregivers who could take care of you at some point? Do we need to start planning for what that looks like in the future? And there are resources out there, right? AARP has like a checklist you can get with questions to ask if you go to a nursing facility and walk through it. But I think that unless you're going to be very proactive, right, and actually start interviewing facilities and walking through them, you're going to find yourself in that crisis mode every time. And I think that for most of my clients, and they're in their 70s, they don't want to think about the fact that they might need nursing home care in the future. They don't, sometimes they don't want to talk about it in that meeting, and I force them to anyways. And there are others who are more proactive. I think though, and Hannah, you can tell me if you see differently, but I think the people who are being proactive are not the people who are going into the facility. It's their kids, right? It's their loved ones who already see, I'm in this sandwich generation. Mom is getting older. My kids are getting older. I can't handle both. So let me figure out what I'm going to do with this part of my life when the time comes. So I have a lot of those meetings with the children where they just say, I just want to know when the time comes, what can I do? Who can I talk to? Where do I go? And those are the ones that when there's an emergency, they're not panicking, right? When their mom is in the hospital and their social worker's calling to find facilities for her to go to, they don't panic. They just tell the facility, listen, I need you to send that contract over to my lawyer. She's going to review it before I sign it, right? But it's not usually the resident who's doing that. So Hannah,
I agree with that. I agree with that 100%. Like the pre-planning are the people who can see it on the horizon, who understand that they're going to be a caregiver for somebody. Maybe it's because their loved one has a diagnosis of a degenerative condition. So they're already looking at those things. Those people that are pre-planning know what to expect. And part of the problem though with pre-planning too much is that the laws change and the agreements change. So like what we're telling you today is what we're seeing today. What those contracts might look like in 5 years might be a little bit different. So at least with somebody who's pre-planning, they have that relationship with an attorney. They know like, okay, issue spot. I have to sign a facility contract. I don't know what I'm doing. Let me call my attorney, something like that. Then they might still be panicking about the care of their loved one, but they know what to do. They know who to call. They have a resource. And then, a lot of times when people are in crisis, and they haven't planned, that's when they're like, just whatever I need to do, just put whatever piece of paper in front of me I need to sign. And those are the ones, I agree, Jennifer, those are the ones where we see a lot of issues. And the pre-screening by facilities isn't really common because they don't know when you're going to be in crisis and need that care. They, and every facility does things a little bit differently. So it's not like you could say, if I need skilled care, these are the terms I'd like to agree to in a contract, and kind of go ahead and think that through. Or if I need assisted living, this is what I'll need. It's going to depend on what they ask of you in that moment, what documentation they're going to need, what, the contract's going to say, and they're all individual. There's not like a form standard agreement that you could, pre-think through. So it's really hard to do it ahead of time.
And then the other part of that question about, is there an organization that reviews these that people can go to? I think unfortunately the answer right now is probably no. If you want to get legal advice on a contract that you're trying to sign, you're going to be put in a position of having to probably pay for that advice. I don't think at this point legal aid provides any type of service reviewing admissions agreements. Might be a great thing for them to take on, but what they'd have to do is rely on private practicing attorneys to volunteer our time to look them over. I will say though that many of us attorneys who are part of NALA, the National Academy of Elder Law Attorneys, we do volunteer our time in different ways. So in my county, I have basically come up with an agreement with our Senior Resource Center. And when the lead, the supervisor of the social workers at the Senior Resource Center has a family member come in who's part of their caregiver group who needs legal advice and they don't have the resources to pay for it, he usually refers them to me and I do pro bono services, right? And that's just part of an elder law attorney in general. I think every one of us who do elder law work, we started out not because we were going to think we were ever going to make a ton of money. It was about the clients we were going to work with and our mission, right? And our mission is to help those who are most vulnerable, and families trying to get a loved one in a facility after an emergency are incredibly vulnerable. And so don't be embarrassed to pick up the phone and just ask. You can go on the NALA website and find all of the attorneys in the state who are part of NALA and just call them. I think many of us would, we've got consult rates, we have discounted rates, we might be able to do stuff by email to do it for less. We might have a colleague that we know has the time who could do it and help out. But it's just better to ask those questions and have it reviewed. Because honestly, if you pay an attorney $250 for an hour to look over an agreement, and that saves you $150,000 judgment later, it was a really good financial move to pay that money for that review.
Yeah, I agree with that. All attorneys have an expectation that they will do a certain number of pro bono hours a year. And of course, we can't tell attorneys how to spend that time. That's all attorneys though. But I think elder law attorneys in particular honor that maybe to a higher degree with everyday folks than, your, high level contract attorney or tort attorney at a big firm. So I think you're going to find that a lot of us are willing to do things, even if we can't do things for free, but do things for a reduced rate. I've seen that a lot.
Yeah.
Also, I think, your ombudsmen are really good resources. There's ombudsmen throughout the state who are really, really expert at just all things long-term care. They cannot provide you with legal advice. But I know, for instance, where I am, I'm in the Piedmont Triad, I'm in Greensboro, and sometimes I'll get an ombudsman who will call me and say, hey, I have this situation. Can you, I can't give them legal advice. I don't want to tell them what they can or can't do under this power of attorney. It feels wrong to me. Am I on the right track? And I can't give anybody legal advice, but I can set them on the right path. I could give them some information that kind of keeps everybody feeling like they're in a good position. Or I can refer that I can take it on if I can. I cannot take on cases because I have an in-house position. I can't do that, but I could refer them to a colleague who might be able to do that. In some places, there are law schools. So there used to be law schools that had elder law clinics, and that's where law students are learning this area of law, and they are doing legal work for community members free of charge under the supervision of a practicing attorney. And those are really great situations. I think the only law school that may still have one is at Campbell. I think there's a small program at Campbell, but you could call, you can find those resources. Your local ombudsman's going to know those resources. They're going to know the attorneys that are willing to, have a consult with somebody either for free or for low cost, and who's experienced in this area. Because not everybody who does contracts knows a thing about nursing home contracts, right? So they're going to know the attorneys that they could call on. And I think this is a good opportunity, Jennifer, for us as an outgrowth of this to do some additional training for attorneys at Legal Aid or anywhere else to make sure they know what to look for.
Yeah, absolutely.
Thank you. We've got one more question. So I have POA for my husband, and I'm financially responsible for his medical bills. Now, or am I, I'm sorry, financially responsible for his medical bills now and after his death?
Ooh, that's a complex one. Well, in North Carolina, there's a spousal support obligation, but there are also, so because it's the husband, it's a little different than if it's just a POA. It's a slightly different situation, but and then after he passes, Jennifer, why don't you talk a little bit about estate administration and how that fits into this and the responsibility of the spouse?
I think there's a term called doctrine of necessaries. And so spouses have a duty to support each other. Even if you're acting in a fiduciary capacity, there's some duties that you owe to your spouse in supporting them. And so if you're in a position as that you are paying bills for a spouse and you see your own resources are dwindling because you're trying to pay those bills, you really need to sit down with someone to figure out if you're at the point in your financial situation that Medicaid makes sense. Especially if he's in a skilled nursing facility. There are ways to protect assets for what we call the community spouse, the one still living at home. It gets really complicated because if a bill has run up at the nursing facility, it's not paid, when your spouse passes, that bill is a debt of his estate. And through the estate administration process, creditors are supposed to get paid first. Now, a surviving spouse is entitled to the first $60,000 of their deceased spouse's estate before any creditors. And so the position that you're going to be in if there's a debt to the facility after passing is how far would the facility push it, right? Because if the facility says, well, that was a debt for him and we don't have anyone else to hold responsible, and they walk away because they feel like the only way they can claim is through his estate, then you're covered. But there are facilities out there that are going after surviving spouses under this doctrine of necessaries language, saying that you owed a duty of support to the spouse and that you have to pay the bill. And the debt's not technically just his, the debt is also yours. So, if you're in that position and you haven't put yourself in the position yet, you can't pay it, you want to figure out at what point do you transition from this private pay where you're covering everything and putting yourself in a financial burden, right? Where can you get to the point that you're getting benefits somewhere else so that your spouse can stay where he is, get the care he needs, but you're not going bankrupt in the process?
And just a note on that, part of the reason you want to switch over to Medicaid when you can, or special assistance or what have you, to a public benefit program instead of the private pay is because it's different when somebody passes away and they're receiving a government benefit like that to cover the cost of their care. There's a process called estate recovery where the state can go after, the state of North Carolina can go after the estate to get Medicaid reimbursed, what they paid out for care, to get that reimbursed from the estate. But there's waiver of that for surviving spouses living in a home, for example, and some other things. So there are some protections that are different than just like the facility coming after you for care. It's then Medicaid coming after you to repay them for care. And those are two slightly different things.
Yeah.
And you're a little bit safer, I think, I don't know, with the state coming after you after a spouse has been on Medicaid.
Yeah. So just like pull back the technical for a moment. If you can get your loved one on Medicaid, then it is their estate that is responsible for paying Medicaid back. Medicaid cannot come after the spouse because we have a federal law that says so. But if they never go on Medicaid and there's a debt from the nursing home against your spouse, I don't know what
Open
to tell
question.
about the doctrine of necessaries, because it's going to depend on how much the facility wants to push.
And in some states, they have doctrine of necessaries that even applies to adult children. We don't have that in North Carolina, as far as I know, but some states have that and are even going after adult children, which is scary.
Any other questions, Ashley?
No, thank you.
All right, so now we're going to dive into this one I hate the most. Arbitration agreements in admissions, or arbitration agreements within an admissions agreement. So let's just knock this off assisted living facility. There are no regulations. And so if you're trying to get your
Wild West.
Wild West, if you're trying to get your loved one in a facility and the assisted living facility puts an arbitration agreement in front of you, there's no federal law that says they cannot do that. And there's no federal law that says they can't require it in order to admit your loved one into the facility. So Hannah, you want to cover the skilled nursing side?
Well, I'm just going to take a step back and review what an arbitration agreement is. Because again, I think sometimes we're like assuming people have a level of knowledge. And if you already know this, tune out for a second. But arbitration agreements are designed, they're put in contracts and they're designed to avoid litigation. So the history on arbitration in this country is really like, businesses doing business with each other, that are highly technical terms and things like that. They don't necessarily want a jury of their peers, debating, whether this widget does this technical thing it's supposed to do. Like their contracts are very technical and they would like to have sort of the a contracted way to limit their liability and to have, people in that industry reviewing their claim and making decisions. And so arbitration agreements have been around a long, long time. In terms of like consumer contracts, they really haven't been very prevalent until like the 90s, when there was definitely an uptick in litigation, certainly with nursing homes. And so as there's been more and more litigation about what's going on in nursing homes and whether people are getting care, whether there's negligence claims, all of that liability, nursing homes are looking to sort of limit that. Say, how can we limit that? How can we how can we sort of keep this tight? And they started putting arbitration agreements in their contracts about that time to avoid having to go to court and litigation and that whole process. And it saves them money because it's a sort of a prescribed process. You don't have a right to a jury. You don't have, a lot of the protections of all the process and civil procedure protections that you would have in a litigation matter. And you also don't have the right to appeal. So kind of whatever these people say is it, and it's three people who usually have experience in an industry. And in this case, it would be, people who are experienced with nursing homes, and more than likely they're going to be nursing home administrator favored, not consumer favored. And so that they started putting these agreements in contracts and just kind of slipping them in there. And so when you sign the admissions agreement, it includes this provision that you will arbitrate any dispute. And not, these disputes are like before there's even a dispute, like we don't even know that there's going to be a dispute, but like if something really horrible happens to you in this nursing home, some egregious, almost criminal act of negligence, you can't sue them if you've signed that agreement. You can't sue them. And so this has been a problem. We've fought against this for a long time, and it's sort of waffled back and forth about what the rule is for arbitration in nursing homes. So there's a Federal Arbitration Act that allows arbitration broadly. And then there's specific industries that sort of get, whether or not nursing homes fit into that, kind of has gotten carved out differently over time. And it kind of depends on who is in office at the time. It's political. So there were big changes in 2016, and there's like consumer changes, and then like the nursing home lobby fights back and says we're gonna, we don't want to take all these protections away. And so there's just fighting and fighting and fighting. I think we've determined the most recent rule is in 2019, and there are some consumer protections now in place for nursing facilities where they cannot require residents to enter into a pre-dispute arbitration agreement. And they have to, there's a variety. I think you had in our notes, Jennifer, there's a variety of protections that are in that. Do you want to speak to those specific protections?
Yeah, so number one, they can't require it for admission or a continued stay in the facility. They have to explicitly tell the resident or the family that they do not have to sign the arbitration agreement. That language has to actually be in the document. That it can be rescinded if it is signed within 30 days of signing it. They have to provide neutral arbitrators from both parties in it, provide a selection of venues for the parties, and it can't contain any language that somehow encourages the loved ones not to communicate with federal or local officials, blah, blah, blah stuff. But I think the big picture is if you see an arbitration agreement in a packet of the admissions agreement, it has to say in there, in that language, that you do not have to sign that. And you do not have to sign it. And even if you accidentally do, you have 30 days to take it back and say, never mind, I didn't mean to sign that document. What I will tell you, the most recent admissions agreement that I reviewed from a local facility, they slipped the arbitration agreement in the middle of the packet. It was intentional. It was not a separate exhibit. So we had 5 pages of the very basic, this is the level of care we offer. This is, the daily rate, all that kind of stuff. And then we got to a page that was the arbitration agreement. And then the page after that was the signature page. But that signature page did not tell me if that was a signature page for the arbitration agreement or for the pages before that. So if I hadn't paid attention and just, flipped through and thought, well, there you go, there's no arbitration, because usually it's an exhibit attached or an addendum attached to the agreement, but they had slipped it in. And it had all the language that said you don't have to sign this, but the signature page was separate. So we went through and crossed a bunch of stuff out. But I think that, facilities know that they can't require it and they have to tell you that they won't require it. But that was very deceptive. That was intentional by this facility, the way that they put the packet together to confuse folks that they would just sign it. Any other thoughts on the arbitration agreement, Hannah?
If you do see one in a contract, mark it out. You can cross it out. There's, that doesn't void the contract or anything. That just says, I don't agree to that provision. And one thing you might want to make sure you do is keep a copy of that contract that you signed, because especially if you cross something out, because if you cross something out, what you don't want to have happen is years later when there's a dispute and you're trying to figure it out, they just present what their contract, a form example of what their contract was at the time. If they don't provide the one that you signed, will you cross something out? Maybe you initial it too, not required, but helpful. If you don't have that copy to present, then, that could be problematic for you in terms of whether or not you bound yourself to that agreement. And then also, I was thinking, I think I read too that, a lot of times arbitrations aren't public record, like court and litigation is. And so one of the things that is also a protection is facilities are supposed to keep copies of the arbitrations that they enter into in their facilities and make them available to state reviewers. And that was new in these provisions as well, is that they have to keep copies of that stuff on file, so that other people reviewing the facility can investigate those issues as well. That wouldn't be as obvious because they're not court cases.
And what Hannah suggested about keeping a copy of what you actually sign, that's probably the best advice you can walk away with, because in my litigation that we've had that problem. We've asked, they filed their lawsuit and the agreement that they attached is not the agreement that was signed. They slip in pages. It's not like, most attorneys, we do wills, we have the person initial every single page of the will, right? These arbitration agreement or the admissions agreements in general, you're not initialing every page. Out of the 70 pages, 45 of them is just information. There's nothing for you to sign or do on a certain page. And so they're really bad about, they just take your signature page and they put it with whatever the agreement is. They're also really bad about when they send an admissions agreement over, they don't actually fill in any of the information about what the daily rate is or the monthly rate or any of those things. And so, you got to protect yourself by making sure that it's completely executed, it's all done, and you've got a copy of it. So I think at this point, Ashley or Christina, were there any questions on the arbitration agreements?
We have two questions. One is in the question and answer. It says, has a handout been created by an attorney that can be given to a patient or their family about this information? So it's kind of two parts. Do you want to?
That's wonderful. So Hannah and I were just talking about this last night. So for about a year now? For about a year, NC NALA, we have been talking about and going back and forth on our board about putting together some sort of flyer to give to the ombudsman and other organizations to pass out to folks. And I had every intention of having one done before this presentation. But what I told Hannah is that the hard part is, I know what I think everybody needs to know, but maybe people know more than I expected. And so the hope is that after today's presentation and with the questions you all have posed, that we can take that information and put together some sort of flyer that the NC NALA would put together and provide to folks. So great question. I'm sorry that we don't have it ready now. But that's the goal. Part of NC NALA attorneys is educating the public, and this is something we feel like we need to do to get the word out, other than billboards, but those are expensive. So if anybody wants to give the money for a billboard, we'll get something put together.
And I want to give them to hospital social workers as well. And I wish we could make it some kind of like requirement that they have to give it to somebody. I don't know if they would, or how like ombudsman information has to be posted in a facility. I want information like about arbitration agreements that has to, or not arbitration agreements, but admissions contracts that has to be posted like in hospitals prior to discharge, paperwork that people have to be given. But, dream big, right?
Yeah.
One step at a time. Y'all take this knowledge home and tell everybody else.
Yes.
Get an attorney when you have to review this nursing home contract.
Okay, so a couple more questions have came in. Here's a question. I think this is pertaining to the information from previous, but it says, is this spousal financial obligation why many divorce?
Okay. So there are some elder law Medicaid planning attorneys out there that do encourage a divorce when a loved one goes into a facility. And I think that I'm not a family law attorney, and that was intentional. But what people need to remember in North Carolina is we are an equitable division state, which means that the way it should work, and I know divorce is nasty, but the way it should work is all marital assets should be split equally. And so depending on what assets actually exist and what protections the community spouse might have just because they live in the home, right? And the way assets could be titled, divorce, you might actually lose more. I think that what you want to be careful of is, number one, can the resident, the person actually going in the facility, do they even have capacity to go through divorce? Right? Can they advocate for themselves? Will a guardian have to be appointed for them because there's a conflict of interest for the power of attorney agent to also handle the divorce for the person they're divorcing? I think that you have to be careful of, again, knowing what assets are there, which assets are in the marital asset pot and which ones are in the non-marital asset pot and how they're going to get split up. And you have to think about too, in North Carolina, all the rules about you got to be separated, right? You can't be together. So you can't start this process where you're both still living in the house. So do you start it when they go into a facility, and how are you paying for the care then? Are you able to do some sort of equitable division agreement and get a court order on that? Or is that all going to happen after the divorce is entered a year later? Medicaid does not have to honor, a separation agreement. They have to honor the divorce decree and how things are split up, but it's the court order that gets you there. So I guess short answer is yes, there are people who utilize the divorce to protect assets, but I don't think it's a simple solution. I think you really do have to explore what other options are available first.
And I think in some states it may be more common. Like I've heard in North Carolina, we have some other planning techniques we can do, and protections for the spouse. And like Jennifer said, there's a lot of other things that we can do before we even think about that. As an elder law attorney in practice, I can think of maybe only one case where we got to a point where we were like, you know what, that's really maybe an option you should consider. Like it isn't even something that we talk about unless the client raises it, and it's not something that we encourage for this purpose at all. There may be other reasons. I know, like, when one thing to be careful of is if this happens sometimes, and I'm amazed, but like people get married and then like separate forever and never, ever, ever get an official divorce. And this is a case where I would say it's really important to actually do that, like go through that process and get that divorce so that you're not on the hook for somebody else's medical care and obligation. So I've seen that happen a couple times where I've helped somebody get to the finish line on a divorce that they should have gotten years ago. But so that would be a protection you'd want to place, but not as a first consideration as a planning technique for qualifying for care or anything like that. That's not usually.
And I'll just give my 2 cents for anyone who's older out there who is in love and they're thinking about marriage. I just would really think about the long-term care planning aspect of that. I've had too many couples come in where one of them has a ton of assets and kids they want to leave it for, and the couple really doesn't have anything. And the moment they get married, the protections that we have, right, a lot of those go away. And so I don't know. I know everybody wants to be married when they're in love. I get it. But you really want to think through that, right? If you're 75 or 80 years old and you're looking at getting married, does that make sense? Like, what's your health, right? What's the long-term care plan there?
It's a good point. Good point.
Okay, we've had a few more questions to come in since. The next one says, would you need the facility's signature on the arbitration page agreement if you mark through your agreement to the arbitration for legal purposes?
If you mark through it and you don't sign it, you're not bound by it. So you don't need the facility to do a check that says, yep, we understand you didn't sign this or anything like that. If they sign it and you don't sign it, it's still not binding on the individual who didn't sign it, right? The fully executed agreement is going to require all signatures.
Okay. The next one says, would you say putting your initials on the bottom of pages you reviewed would be a good practice to keep from them slipping in new pages later? Prove what is the original document.
Yeah, I think it's a great idea. Yeah, initialing at the bottom that you've reviewed that page and move on. At least it's another form of proof, right? If they do try and slip something in.
Okay. The next one says, I guess we need to approach all of it with the assumption that during admission, be prepared to look carefully for things slipped in. So I don't know if that's a question or just something you want to comment on.
Yeah, I want to say too, I don't want everybody to think that like all nursing homes and assisted living facilities are like sneaky and trying to slip things in. I don't think a lot of it, I don't think is intentional. Jennifer mentioned a situation that was clearly intentional, but I think yes, you should always review everything carefully, not because something is slipped in, but just because you're entering into an agreement for a lot of money to provide, life or death care for somebody you love. And
Yeah.
so, it's just important to review it super carefully, not necessarily because something is slipped in, they're trying to be sneaky, but there are things that get missed. Maybe it's an old version of a contract and they're like, oh, they don't even realize that they made packets 3 years ago of 300 packets of admissions and they're still handing those out. They don't want to throw them out and make new forms or anything yet, or I don't know. But there's lots of reasons why they might be working from an old document, and it may not be intentional, but definitely read everything you sign, or if you're uncomfortable with it, send it to an attorney.
And I think I said this at the beginning too. I think the folks that you're sitting down with at the facility, going through the contract with, I don't think that there's any bad intent on their part. They've been trained. This is the document that you need to go over, and this is where they need to sign. They're not contract attorneys, and they don't, they're not the CEO of the company that owns the nursing home, right? They're doing their job. And so, those folks are in that position because they're probably really good at helping a family navigate, right, the scary time of placing their loved one in a facility. So I don't want it to seem, the one where it was intentionally slipped in, that's not from the local person. That's from the attorney's office or the corporate office in Virginia, right? It's not the person that I work with on a daily basis. And I call them up and say, how's this person doing? Can I come visit them today? What's their schedule like? When did they do rehab? Right? Those folks want to help. And so please don't walk away from today's presentation thinking that we think all nursing home folks are villains. They're not. It's just, it's a business, right? They need money to run and they got to figure out how they're going to get paid to provide a service. But you shouldn't put yourself in a position that you've got to deal with a lawsuit later because you didn't know what you were signing.
Okay, I think there's one more question and one more comment. The next question says, are you aware of any state reviewers looking at arbitration agreements?
I'm not, but I don't review what the state reviews either. And I don't know that that's part of their typical standard thing that they ask to see, but they're allowed to ask. I don't think the facility has to proactively share, oh, here's all the arbitration agreements we've entered into. But I think state regulators are entitled to ask for it. And if they're asked, they have to disclose. I don't know if that's on their checklist or not. And maybe that's something else we can kind of research and advocate for.
And this last, again, is just a comment. It says, yes, please, would love the handouts. I'm in a hospital and happy to be a resource about this if you need a hospital case management, social worker connection. So
awesome.
And that comment is in the comment section. So
thank you, Minda. I want you to send me an email so that we stay in touch. My email is hannah@corpguard.org. I'm sure it's on the presentation as well, or we just want to make sure we do actually connect with you after this call. Thank you.
So here I was thinking, Hannah, that we would run through this fast, and we have 15 minutes. So
let's do it. Let's go to this. We're done with it. Yeah.
We're only halfway through the slides. Okay, here we go. Discharge. This is the final pitfall that we're going to cover. Now, for discharge, believe it or not, we actually do have some state law that tells assisted living facilities when it is an appropriate time to discharge an individual. And then for skilled nursing facilities, again, the Nursing Home Reform Act has told us appropriate ways to discharge someone. So they're on your screen. I'm not going to like read every bullet point to you. Just know for an assisted living facility, they're really focusing on the appropriate time to discharge someone to be if that individual's, not they're not safe, right? Either they're not safe or they're posing danger to other people. If they're not paying their bill, they can be discharged. And then basically, if there's some sort of mandate that they have to be discharged, we have assisted living facilities that have been shut down. Obviously, they got to go somewhere. But the focus in assisted living facilities is that, right? It's safety. Is this the right level of care for them? And are they paying their bill? For skilled nursing side of things, again, it's failure to pay. Are they posing any danger to the safety or health of others? Do they no longer need that level of care? Can the facility just not meet their needs, or that the facility is closing? But what I want you to take away from both of these, right, is it is not an appropriate form of discharge because the admissions agreement has not been signed. And so, if nothing else, if you can get your loved one in there, they're there, and then you take your time to review that admissions agreement, but they can't just discharge them because you haven't signed it yet. Okay. And so if they are bought out by a different company and they give you a whole new admissions packet, they can't just kick your loved one out because you're going to take the time to review it and make sure it's appropriate. And maybe you're not going to sign certain things. I think that when it comes to discharge, I always lean very heavily on my ombudsman, okay, because they get notified of the discharge. They get notified of the reason why, right? And they are a huge advocate for the resident. And so if you get that discharge notice and it is not an appropriate discharge, you talk to the ombudsman, call the person that they should be listed on the discharge notice so that you know how to get in touch with them and talk to them about that. Hannah, you got anything to add to the discharge?
I don't. Honestly, your ombudsmen are so good at this that they're really the best resource, and they'll call us if there's something they need, higher level us to jump in on or, sink our teeth into with them, but they're your best resource on discharge. I agree that you do not have to sign the admissions paperwork in order to avoid a discharge. That shouldn't be the case, or you should at least be given time to review it. So agreed.
All right. There are some other potential violations in admissions agreements that do have some regulations. I just wanted you guys to see them. So for an assisted living facility, we do have a law that says that the facility cannot put in their admissions agreements any waiver of the rights that the resident has under the resident's Bill of Rights, right? And that, I think, was all covered in a previous webinar. The Resident's Bill of Rights is really easy to find on the internet so that you can see what a person's rights are. But if there's anything in the contract that tries to violate rules about visitors and things like that, that is against the law for assisted living facilities. So you should make note of that. Skilled nursing facilities, kind of the same thing. The Nursing Home Reform Act makes it clear they can't request or require that the resident waive their rights to Medicare, Medicaid, or require that they waive their rights to the Bill of Rights or liability. This is the one that I think is awesome, is the liability for losses of personal property. Assisted living facilities have that in every one of their contracts, all of them. So if we lose your dentures, that's not our problem, right? You're just going to get new dentures. But nursing facilities technically cannot have that in their contract. So I know everyone gets really frustrated because they buy clothing, right, for their loved one, and the facility washes their clothes and the clothing never actually makes it back to their loved one's room. Or you go and visit them and you realize that the nightgown you bought for your mother, the person next door is wearing, right? They're not allowed to do that. They cannot use an excuse of they're busy or their visitors in there. They're liable, and they're supposed to help you protect your own personal property that's there. Now, that being said, you should not allow someone living in a facility to keep all their jewelry, right? Probably a bad idea to have that beautiful diamond ring there. Having family photos is great, but probably not having a Picasso hanging on the wall, right? You just want to be smart about what you have there. All right. Okay, so the wrap up is, what can you do, right? I think my number one, and I didn't even put it on the slide, if the resident has capacity to sign their own admissions agreement they should sign their own admissions agreement. Stop
Hey,
doing
Jennifer.
it. It's easy.
I'm going to interrupt you only because I see the question in the chat on
Yeah.
that very topic.
Yeah.
And I think you should address it now rather than letting it go further. But the question is the agreement valid if the facility has the person with cognitive decline sign it?
Oh, good
So,
question. All right.
Yeah. So it just fit right in with what you just said. So I think
Woo.
let's go ahead and
Yeah.
tackle that one.
So what you need to know about contracts is there's a difference between void and voidable. Okay. It is void if the individual has been adjudicated incompetent and they cannot make their own decisions. There's a court order that says so. Void contract. It's voidable if they lack capacity to sign it. So there's no court order out there that says they completely lack the ability to make decisions for themselves and they have a guardian appointed. So it's voidable, meaning that if they sign it and you think they didn't have capacity to sign it, you may have to take some sort of legal step to have the contract voided at that point. So most facilities don't want to deal with that battle because they should be pretty well aware if the resident at the facility has the capacity to sign a document. And I think that is why often they just grab the family member that's coming in to visit at the front door and say, hey, we got a lot of paperwork we need to go through. Can you come sign it? Right. And so I always tell, okay, when I represent an agent under a fiduciary, like a durable power of attorney or healthcare power of attorney, those are supported decision-making documents. They are not documents that give the agent the ability to just take over. So I believe that an agent under those documents has a fiduciary duty to determine if their principal has the ability to make these decisions themselves. So if you are acting as an agent and you go to the facility and you feel like the person you're helping has the ability to make their own decisions, then you need to stop the admissions director and say, I know you want me to sign this, but it's not my contract. And I think we need to go over it with mom or dad or whoever you're the agent for. If you believe they absolutely lack the capacity to sign the documents, then don't put them through that process, but then you need to be smart about how you're signing it.
I agree. And I would say the agreement may be valid initially, but you have a defense to it.
Yeah.
So like if the facility is then trying to enforce the document that an incompetent resident signed, and when I say incompetent, I shouldn't say that. Somebody with diminished capacity,
Yeah.
somebody who hasn't been declared incompetent by a court, but somebody who they know or should know because they're helping them with their medical care does not really have the ability to understand or sign. If they're having somebody sign that, I think you have a really good defense on the back end to whether or not it is actually a valid agreement that's enforceable.
Yeah. So you want to take the time to review. Most facilities follow this contract rule of you got 3 days. Honestly, I don't find that in any of the regulations. So I think it must just be a North Carolina contract thing. But, every facility that I've had clients deal with, they have been fine to give them the admissions agreement and say, go review it, sign it, and bring it back. I mean, they'd love for them to do it right there in the facility, but they know that they have to give them the right and the time to read it. So I think, that's your first step is you need to read what you're signing. And if you're not going to take the time to read every single page and every single line and understand it, then go pay somebody to do it for you to make sure it's read. You can speak with your ombudsman. I think that's why the very top of the list here. Again, we have a very strong ombudsman program in this state. I practiced in Alabama before I came here. The ombudsman program is set up so differently. And I don't think that people understand what a wonderful resource we have here. So use that resource, talk to them, get the advice, get them to put you in the right direction of who else you should talk to.
And they're not attorneys, but they're good at issue spotting. So they might see they might look at a contract that you don't know what you're looking at and be like, I think that's an arbitration agreement. Like maybe you should go talk to an attorney. Like they can issue spot even if they can't give you advice.
Yeah. And we've said throughout the whole thing, seek legal counsel. I know we're lawyers, and so you just expect us to say that anyways. But I think there's a benefit to paying for legal advice on the front end to save yourself a lawsuit where you're getting sued for thousands and thousands of dollars. I mean, we're talking about folks who get put in a position that they're filing bankruptcy for a debt that shouldn't have been their debt to begin with. You shouldn't ruin your financial future because you didn't want to take the time to talk to somebody. So seek that legal counsel, let them mark out terms. I will sit across the conference room and walk through a 90-page document and cross out everything I hate right then and there, and then let the client sign it in front of me, and we make 1 million copies of it, and then we send it on, right? But take the time to do that. There are,
And sometimes they'll make it go up a level, like, if you're making those changes, the admissions person might look at you like, I don't know what to do with this. I have to send it to my supervisor kind of thing.
Yeah.
I'm not sure that this is going to go okay. And they're like a little miffed that you want to change their contract and you don't just want to do it their way. Don't let that bother you. Let it go up. Let that person, I've talked to higher ups at facilities before. I've talked to outside counsel before. Sometimes if facilities are really paying attention, they might want to do that and have a higher level review, but don't let that intimidate you or anything. Let them go through their process.
Yeah. There are reporting agencies. So this is just going to be my practice from now on, and we're going to get into it in just a minute why. But if you see an admissions agreement that has something that violates the law, you should report it, period. Even if you're going to mark stuff out and sign it and put your loved one in there, report it, because all you're doing is helping everybody else, and we should be helping each other, right? If we have a facility that's in Brunswick County that keeps putting this voluntary section in there about being personally liable for the debt, and we know that violates federal law, we should tell somebody about it so they can do something about it. It doesn't necessarily mean that you have to file a lawsuit, but reporting it is just fine. So you can report it to the North Carolina Division of Health Services regulations. You can report it to the state attorney general. I don't know how far you'll get, but it's somewhere to go. You can talk to a lawyer about filing some sort of affirmative action, unfair and deceptive trade practices. That is a very popular thing that is taking off in New York and other New England states. Because they're seeing so much more of the lawsuits against individuals. Now they're doing cross claims and cross complaints against the facilities for unfair and deceptive trade practices. So like that example I gave you guys about the arbitration agreement that was slipped in there, that was deceptive, absolutely. And if that person had signed it and we ended up having to battle this arbitration agreement later, absolutely would we file something like this, right? Because it was deceptive. And so the reason why I'm all about reporting now is this is a big hot topic now. The Consumer Financial Protection Bureau, they're the bureau where they do the Fair Debt Collection Practices Act and they handle the Fair Credit Reporting Act. So if you owe a debt to someone and they file a lawsuit against you, or they report that debt to creditors, right? So now your credit score is tanked and you can't qualify for things. It's the CFPB, right, that really regulates all of that. And on September 8th of last year, they actually held a virtual discussion about nursing home debt collection. And they had community leaders, folks from all kinds of organizations participate. I sat in and listened. Eric Carlson was there, people from AARP, like some really big names. And they were all united in the fact that we have a huge issue with nursing home admissions agreements and the collection of debt from nursing homes. And so after the CFPB held this virtual hearing, they pushed out a lot of circulars and joint letters and things like that. And so the circular went out there and it was, about the practices of nursing homes and debt collectors, and that they may be violating federal laws if they are going after individuals who have signed admissions agreements that violate the Nursing Home Reform Act. So basically what they're saying is if a nursing facility has that voluntary language that they're not even allowed to ask in the first place, and then they go after an individual who has signed that and they sue them and they report that, there are now two acts that they have violated. Right. And it is a complete violation of federal law. And I think what the CFPD is trying to do is get out there to the nursing facilities and the attorneys that represent the facilities to say, these are really bad practices and you have to stop doing them. I don't know if it's fallen on deaf ears or not, but the fact that we have, a federal organization that is finally doing something, it's very nerdy. It's a big deal because they haven't done anything on this ever. So I think that, they can't enforce compliance with the Nursing Home Reform Act, right? That's not their job, the CFPB, but they can enforce, right, the fair debt collection and the fair credit reporting stuff. So If you see an admissions agreement that comes through that you believe violates all that, this is another place to report it, right? Most of these nursing facilities are owned by huge hedge funds now, right? They got a ton of money. And it's nothing to them to have, 50 different law firms that file all these lawsuits because it doesn't cost them that much. So we got to stop it. And the CFPB is asking for people to report it now.
And reporting is just good practice in general because, at all levels, because I mean, these are issues the CFPB is raising. They're big picture systemic issues, and they're coming at it from that angle. But your local ombudsman collecting a bunch of data will help, helps everybody identify like, oh, well, this assisted living, their contracts always have this issue in them. And so they know, like, they can tell anybody they're talking to who's going to that facility, like, you really probably should get an attorney to look at this or something like that. So just having that data is helpful for other people, and bringing things to the level of the attorneys. Our organization is an advocacy organization that the NALA, the North Carolina chapter of NALA, and we occasionally will join in litigation and write like an amicus brief, or we might come up with some strategy, and we've talked about this, like reaching out to the nursing homes directly, like their legal people, and trying to have a conversation about, help them not violate federal law, which helps our clients. So, I mean, if we know what the issues are, we can help address them even on a more local level than the CFPB looking at things.
Yeah. So this slide just, this is more language from the circulars and the letter that CFPB put out, just saying that if a debt collector violates, things that are prohibited, or, those misrepresentations in those agreements, they can be held liable for that. It's inaccurate, right? They use a lot of words about inaccurate and illegal, which I love. And so, if you want to go read those things, they're online at the CFPB website. But again, there's a joint letter, there's a circular they put out. They kind of put out a synopsis of what all was discussed. And so I think, again, it's just another resource to go out and look, I think.
And Eric Carlson, just want to say that Eric Carlson has some good materials too for lay people reading about skilled facilities and nursing home agreements and their contracts, and kind of some other things to look for. We've hit the ones that we see, primarily the issues we see here, but there's other information out there, and Eric Carlson is a legitimate source. It's a good source of information.
Yeah. And so the last slide we have here was just kind of the call to action that CFPB put out, which is, they were saying to nursing facilities and the debt collectors that they really need to examine their practices to ensure that they're complying with all of the laws. And the CFPB has basically made a promise that they're going to continue to work with CMS, which is the Center for Medicare and Medicaid Services. They're the regulatory agency for nursing facilities. And so, big picture, we want there to be global change, right? A small picture, we want individuals that have heard this today, or if you go talk to other people, that you take the time, again, review what you're signing and know that you do have rights right before you sign it. And there may be things that can be done after you sign it. But it's all about slowing down, right? Don't let the emotion and the emergency push you to make a decision you shouldn't have made. All right, Christina, Ashley, any other questions?
The only question is, are you all going to share your slides?
Oh yeah, I'm happy to share them. Just if there are typos, don't hold it against me.
Thank you, ladies.
Yeah. All right.